the first set of cases don't arise. Then comes the second situation. What did the governor do? He is left in Maharashtra without a chief minister. If he is left in Maharashtra without chief minister, he has to invite somebody to form the government. Now he had then two options. He has invited Mr. Shinde to form the government. Should he have not allowed Shinde to continue without a floor test? That would have been worse than conducting a floor test. Where are we in this case? Everything is academic. Yes, the only thing which remains is the 36 pending disqualification petitions which the speaker will decide. And if he gets them wrong, there is the High Court which will correct them. Your lordships are here which will correct them. You have, within the parameters of judicial review, your lordships have tested and corrected these orders time and again. That is, my lord, my first submission. My second submission is what happens pending the disqualification petitions. Your lordship has been shown the judgments, but let's, my lord, sometimes it helps. Let's go back on first principles. Please see two provisions of the Constitution, my lord, and whether your lordships find the answer there. 190.
Yeah, we've seen that actually.
Your lordship has seen it.
We've seen it.
Correct, my lord? The point which I wanted to make is just show your lordship something in the language of 190. Just for 2 minutes.
190 is Parliament. We are more concerned about 180, 69, 160.
The language is identical. I mean,
identical. Correct.
Yes, there's no. The principle of the two is very important. Let's see the compare the equivalent provisions. First, see 173. These are qualifications. Person not qualified to fill a seat. I don't need to trouble your lordship with the details. And then we come to 190, which is houses of the state of legislature. So we are really concerned with 190 because we are talking about state. And 190 sub-article 2 tells your lordships, no person shall be a member of two or more specified, then after the expiration of the period, etc. We are not concerned because we are really concerned with sub-article 3. A becomes subject to any of the disqualifications in 1 or 2 of 19 of 191. So we may not go to 191. 191 applies to at both stages for being chosen and for being a member. B, C are post occurrence of events. Unsound mind and stand so declared by a competent court. A pendency of a petition in a court to declare somebody incompetent is not good enough. Pending insolvency is not good enough. Look at E now. If he is not so disqualified by or under any law made by Parliament. Now, my lord, today your lordship was told eloquently of how terrible it is to allow those hit by 10th schedule to continue. My lord, it is not every time that there is corruption because of which there is defection. There may be times where people may defy a whip. There may be time when there may be a split in a political party. Now that sub-article 3 has gone, you have a problem. And people may say, we will brave disqualification, but this chief minister has to go. But look at, my lord, the Representation of People Act. You may have a person who's elected on which there are allegations of booth capturing, of violence. I remember, my lord, once somebody was arguing the case for one of the persons from Bihar, my lord, who was in jail and saying he should be allowed to come. Mr. Tulsi was arguing and he told Justice Nanavati, he said, see the majority by which my client has won the election. And Justice Nanavati said, if your client had his way, he would have had no opponent. He would have killed all of them. So, my lord, those kind of cases are pending. A person, my lord, a known mafia king, against whom there was a murder trial pending for publicly gunning down people, continued in office.
Where does it?
My lord, we have cases, and your lordships have dealt with these cases in the High Court and sometimes in appeal in this court. You have cases of the worst kind of electoral offences pending for trial. What happens to those people? They continue in office. So, my lord, there is nothing so shocking that in our system, many times people continue in office where there are serious allegations pending against them. That's the bane of our system.
Thank you.
Thank you. Thank you, many.
Now, with that, my lord, see the language of 191(2). A person shall be disqualified for being a member if he is so disqualified under the 10th schedule. So that disqualification must take place. And that disqualification in the 10th schedule does not take place until there is a decision of the chairman or the speaker under paragraph 6. Any other view, my lord, would be equally or would be far more disastrous, because today all you have to do then to paralyze the working of an assembly is to file disqualification petitions.
Mr. Salve,
Yes.
till here there is no problem.
Yes.
The position under the Constitution is very clear,
Yes.
and also the judgments of this court.
Correct.
Concluded with this expression, the decision.
Yes.
The problem arises the time, context, and the stage at which speakers choose to take a decision.
Yep. I was going to straight away address, but
Where are
yeah,
we?
so
I mean, in that,
yes.
it is in that context that
Yes.
either that he shows over anxiety to immediately decide violating principles of natural justice, or he just doesn't decide for times to come. So,
the short
in the
answer.
case of pending 10th
Yes.
schedule proceedings,
Yes.
the powers to be exercised either by the governor or the political process, as it were, goes on.
Yes.
So makes the application redundant many a times.
May I not respectfully answer? This has been the biggest problem of appointing a speaker. Mr. Sibal was right when he said your lordships expressed hope and faith that the institution of the speaker will rise above politics when it comes to the 10th schedule. Our experience may not have fully risen up to those expectations, but that's where we have to drop that. The point, my lord, is this.
Yes.
My lord, respectfully answering Justice Narasimha's question, if your lordship has seen, the rules here have in one sense a constitutional status, because the rules are framed as a delegate under paragraph 8. And those rules can and should provide a time frame in which these petitions have to be decided, both giving fair opportunity. So these rules normally say you will give so much time for giving a reply. One of the reasons why our group came to court is even that time was not given. And equally, perhaps its time has come for the rules to say, if a petition is filed, he shall, unless there are compelling reasons to the contrary, dispose it off in 90 days or 60 days or something like that. And there, my lord, then judicial review will come in. If a speaker is dragging his feet and the rules say he must decide it absent compelling reasons within a given frame of time, judicial review will come in. You can go to a high court and say, issue a writ of mandamus directing him to dispose of, because then you will have a legal right to ask for a decision within a given time. So, my lord, these are the only ways in which your lordships can address this lacuna. Now, what is the relating back? Relating back has two dimensions. The event has taken place. So ultimately, subsequent events will not affect, it will not efface the wrong which you have committed, the political wrong which you have committed, which disqualifies you. It's over. My lord, if you enter into an office of profit, you're disqualified. If you resign 3 months later from that office of profit, it is not saved. You're disqualified on that date. So, my lord, that disqualification is based on a set of events. But please consider the consequences, which will be contrary to the terms of the Constitution, which says no act of the House shall be declared invalid merely because a member participated who was not entitled to. Now, first of all, here you are entitled to participate, but even if a wrong person comes in, you cannot go annulling the work being done. Today, my lord, if when the defection petitions are decided, if some of them are allowed, in between laws have been made, resolutions have been passed by the House, all of them can't be revisited. So, my lord, that's the respectful answer to the ex post facto point. That as a matter of law, and my lord, I read, since your lordships have kept this question back.
What were you saying, Mr. Salve, as a matter of law?
As a matter of law, my lord, I read the Nabam Rabia judgment not as laying down an absence of power, but as laying down a code of conduct. Let me explain what I mean, my lord. The speaker
On the ex post, Mr. Salve, in a sentence, can you just summarize your ex post facto on ex post facto? What is your, so we'll just, if you formulate it, we can take it down then, you know.
My formulation of ex post facto is as follows, my lord. The disqualification will have to be decided on the basis of the acts and omissions of the allegedly delinquent member on that date. But subsequent events will not cure that. If on that date you defied a party whip which was lawfully issued, that's the end of the matter. The fact that the party collapsed thereafter is neither here nor there. If it is pursued to its logical end, that wrong has been committed. And I give, my lord, the example of somebody who takes an office of profit. Let's get into non-controversial.
If you can just continue to sort of complete the formulation, I got that the disqualification will have to be decided on the basis of the acts and of omissions of the allegedly delinquent member on that date.
When he committed those acts.
Will not cure that.
Will not efface.
The call also said.
Will not efface.
So what is the sequitur?
Yes.
What is the sequitur?
The sequitur is, however, until the date of decision.
Yes.
The person is entitled to participate. And Article 189 sub-article 2 makes it clear that his acts, his functioning in the house in the interregnum does not vitiate